Good day and welcome to the Nigerian Law Coach YouTube channel. We'll continue our discussion of jurisprudence in this clip, and today we want to look at the schools of jurisprudence, which in the Nigerian legal curricula will always come up in the first semester of jurisprudence in final year. When we talk about the schools of jurisprudence, we are thinking about the ideas that have been propounded by a group of scholars in respect to the perennial question of the nature of law and justice and the relationship between law, justice, morality. Where is the law sourced from? Now, these are questions that have bothered thinkers over time, and they have made contributions about these questions, and most of the schools of jurisprudence group answers that have the same orientation towards these questions. If you look at the course outline for the first semester, you will realize that we are supposed to go through a variety of schools of jurisprudence, from the natural law school to the positivist school to the historical school to the realist school to the sociological school and to the economic theory of law. These schools are somehow sequential and developed one after the other. So in this first discussion, we will take a brief introduction to the natural law school, and for this discussion we will once again adopt the outline of thought that was prepared by Professor Obinna Okere, a bilingual scholar of the University of Paris, and a professor of international law in University of Nigeria Enugu campus, and a member of the African Union Legal Committee or something. So today we are going to look at, and then also we'll look at some of the thoughts of Dyers, W.M. Dyers, in his book on jurisprudence, and we'll try to merge the two. Now, basically, when we talk about natural law, we're talking about, there was Friedman actually said that the history of natural law is the tale of mankind's search for absolute truth and justice. Now, note that the history of natural law is a tale, the story of mankind's search for absolute truth and justice. So you realize that natural law is really talking about truth and justice. It's talking about things that have a moral content. It's talking about things that might not be so easy to scientifically establish, but which it believes that by virtue of reason you can actually be able to establish what the content of these things should be. Now, it proceeds from this first assumption. It's natural law is inspired by nature, and it proceeds from this understanding that there is a law of nature. Now, it's not something that you can maybe scientifically isolate, but it's a law of nature that determines how things should go, and that this law of nature should regulate human conduct. That's the first assumption of natural law school of jurisprudence, that there is a law of nature that should regulate how everything occurs. Then secondly, it also assumes that there is an objective moral order. When we say objective, it means it doesn't depend on an individual. It's something that anybody can actually isolate. It says this objective moral order is within the capacity of human intelligence or reason to find out, and this objective moral order is also within the capacity of human virtue. That means human beings can obey this moral order. It's not impossible for human beings to comply with this moral order. And it says that this more objective moral order, it should regulate everything that actually happens, and that the individual, national, international happiness depends on this objective moral order. Now, it also has another assumption. I'm listing up the assumptions. I'm actually trying to explain the assumptions on which the natural law school is based. Basically, this is from Professor Carey's line of thought. Now, it also talks about the fact that there is in human nature. We've talked about, first of all, that there is a law of nature. We've talked about there's an objective moral order, and now we're talking about the fact that it's assumed that there is a human nature which is revealed when human beings, it's revealed from the natural inclinations of human beings when they are being guided, as they are being guided by and controlled by reason. That's definitely, it's simply saying that when people are reasoning, that there are certain things that they objectively want to do, maybe things like populate the earth, reproduce themselves, and all of those things, and there is a human nature, and that every individual should actually comply to that human nature. And then the next assumption is that by virtue of this human nature, part of the human nature as well is that human beings have intelligence, and because they have intelligence, that they pursue specific ends, and they're able to accomplish their ends, and then because of this human nature, it says that the human beings also have a purpose and an end, something that they should achieve, and that by virtue of reason, that they can actually discover the best way to live in order to accomplish that purpose for which they are actually created. Now, it also goes ahead when you think about natural law. It's also something that seems to say that there is springing from human nature, that there are rights and obligations which accrue to human beings, which do not depend on the law for its existence. They predate human societies, and they are just universal rights and obligations. That's where you have human rights originating from. And then you also natural law seems to say that any rule of human conduct that goes contrary to the law of nature is just a shadow of law and is unworthy of any obedience. That's where maybe we begin to talk much later about the relationship between law and morality. You will find out that a lot of natural law philosophers will say that unjust law should not be obeyed. Maybe when you get to the scholastic Thomistic, that's based on Thomas Aquinas, that's what we talk about, Thomistic, Thomistic, the Thomistic philosophy, that is that you have no obligation to obey unjust laws, and they are not binding on conscience. We'll find out when we're looking at the stages of development of natural law, and when we're looking at the scholastic era of natural law. And then also natural law philosophy seems to posit that natural law precepts are universal and unchangeable, no matter the social personal circumstances, no matter the geographical differences, no matter the time zone, that these natural law principles are immutable, unchangeable, and universal. I must let you know that a lot of these things are subject to debate, and one of the things you must do as a jurisprudence student is to be able to engage your mind and to ask questions. Are these suppositions actually correct? Are these assumptions actually correct? Or are these assumptions also things that need to be questioned? So in essence, we've looked at a lot of this, and then finally we get to the part that you realize that there is a lot of conflict about people's beliefs, and that brings us to one perennial issue that is always looked at in natural law. That's the relationship between law and morality, because a lot of natural law philosophers will say that law must have a moral content, while positivists will say, well, once law complies with certain procedural requirements, that there is no need for it to have any moral content. And it's been a debate consistently between the positivists and the naturalists. And then, well, like when we teach our first years in legal methods, and we get to talk to them about law and morality, and we tell them about the debate between Professor Hart and Lord Devlin, following the criminalization of homosexuality and prostitution in England, and those cases about the ladies directories case, DPP and Shaw, and Nola and DPP, where the court said that the court is a custodian of morals. And the later discussions that came after that, we might look at that much later in other discussions, but that's the law morality thing. And when you realize that there are so many issues that divide people, recently there's been this same-sex marriage, homosexuality, same-sex marriage, which in Obajavel and Hodges, a United States case of 2015, it struck down the restriction on against same-sex marriage. Now, a lot of people have not accepted that, but the Supreme Court of the United States said that they are learning new concepts of what it means to be free and liberty. So these are all issues. Other things like the issue of prostitution, issue of adultery and fornication, use of alcohol, use of drugs, drug abuse, things about even stem cell research, things about cloning, things about artificial insemination and surrogate motherhood, a lot of issues that are so testy and very right of abortion and all that. These are areas that the natural law school clash with the positivist school, the relationship between law and morals. And then it's something you should advert your mind to realize that the way the world is progressing, that you have to have a proper philosophy and a proper understanding of these two schools, the positivist and the natural law school. Well, having looked at this, we just briefly talk about Diaz's thoughts about natural law, and it made it very apparent that natural law had meant different things to different people at different times, and that's why it's difficult to really classify people strictly into whether they are natural law philosophers or not, because natural law have at various times meant an ideal that could guide the making of the law and administration of the law, and at other times it's meant the moral content that the law must have in order to make sure that there is no strict separation between what ought to be, what we call the ought and the is. That's what ought to be and what is, what ought to be law and what is actually the law. And then he has also talked about it as being the method. At various times I've meant the method for discovering the perfect law, at other times it's meant the content of the perfect law itself, and at other times it's just meant things about conditions for making sure that a law really exists. So these are the various different understandings of natural law that has had over time. And he also explained that there was a time that natural law was a natural law of method, and there was a time there was a natural law of content. And then when to the natural law of method, it was an attempt to discover methods for creating the ideal law, and that was at the earlier stages, the scholastic period and all that. But by the 17th and 18th century, it became the natural law of content, where there was an attempt to make laws from to make ideal laws from absolute first principles, and that approach failed, and that was why maybe in the 19th century positivism took over, and there was a decline of natural law. And then subsequently, when society found it difficult to handle certain problems, natural law came back with an emphasis on social justice, because positive law could not solve problems of abuse of authority, for example, and the issue of unstable societies that had arisen from the positivist concept. So this is where we'll round up this. In the next discussion, we'll trace the history of natural law from the Jewish school. We could have started from the Babylonian school, but we start from the Jewish school through the Greek school, the Roman school, the scholastic period, the decline of natural law, and the classical era of natural law. We'll look at that in the next clip. Thank you for watching, and do subscribe to the YouTube channel of the Nigeria Law Coach, and see you some other time. Thanks.